appeals chamber recalls that there is no provision in the court's legal texts that specifically provides for the interim or conditional release of a detained person on health grounds. Nevertheless, the appeals chamber has indicated that the medical condition of a detained person may have an effect on the risks under Article 58(1)(b) of the statute and may be a reason for a trial chamber to grant interim release with conditions. The appeals chamber considers that such a determination is necessarily case specific. Contrary to the defense's assertion, nowhere did the pretrial chamber suggest that it was precluded from assessing the information about Mr. Duterte's health within the context of its assessment under Article 60.2 of the statute. Rather, it noted the reports placed before it and considered that they were unable to affect its finding on risks under Article 58(1)(b) of the statute. The defense has failed to show that the pretrial chamber's approach was unreasonable. For these reasons, having rejected the defense's argument under this ground of appeal, the first ground of appeal is rejected. Second ground of appeal. I will now turn to the second ground of appeal. Under this ground, the defense challenges the pretrial chamber's assessment of the proposed conditions of release and state warranties. The defense argues that the pretrial chamber erred in law in failing to address the proposed conditions of release and state warranties. The appeals chamber is of the view that the pretrial chamber did not appear to criticize a lack of detail in the proposed conditions, but rather in the details as how the state which accepted to receive Mr. Duterte would implement the necessary conditions. The pretrial chamber did not consider release with conditions as required, but found that in the circumstances before it, the risks it had identified could not be mitigated by the proposed conditions. Moreover, the appeals chamber is of the view that the pretrial chamber was not obliged, as suggested by the defense, to seek further observations from the concerned state, because it did not envisage the possibility of release given the risks it found Mr. Duterte presents under Article 58(1)(b) of the statute. For these reasons, the appeals chamber finds that the defense has failed to identify an error by the pretrial chamber when addressing the proposed conditions of release and state warranties. In relation to the question of whether the pretrial chamber erred in law by failing to consider if the proposed state warranties could mitigate the risks under Article 58(1)(b) of the statute, the appeals chamber finds that this does not appear from the impugned decision that the pretrial chamber would have required an elimination of risks, as argued by the defense. Instead, the impugned decision specifically states that the pretrial chamber did not consider the suggested conditions to sufficiently mitigate the identified risks. It is also apparent from the factors brought forward by the pretrial chamber when examining the implementation of conditions that it did consider them. Finally, the appeals chamber considers irrelevant to which conditions the prosecutor agreed when discussing potential release of the suspect to the host state. What matters are not conditions that may, in principle, be possible in case of a release to a state different to the one proposed by the defense. Rather, what is of consequence for the pretrial chamber's assessment are the conditions and warranties proffered in relation to a release to the state party concerned. For these reasons, the appeals chamber is of the view that the defense failed to substantiate the pretrial chamber's conclusions were unreasonable. Regarding the defense's contention that the pretrial chamber erred in fact and law by taking into account irrelevant considerations in respect to the state warranties, the appeals chamber considers that the pretrial chamber's finding mainly related to the implementation and enforcement of the proposed conditions. It considered the practical implications of ensuring adherence to the proposed preferred conditions in a situation such as the one at hand. It did so against the backdrop of having found that all the three risks under Article 58(1)(b) of the statute were established. As such, it was reasonable for the pretrial chamber to examine how, in practice, the suggested conditions would be implemented. The defense has failed to show an error in this assessment. For these reasons, the appeals chamber considers that the defense has failed to show how the pretrial chamber erred in its assessment of the proposed conditions of release and state warranties. For the foregoing reasons, the second ground of appeal is rejected. Third ground of appeal. Regarding the third ground of appeal, within which the defense argues that the pretrial chamber erred in not considering